Thank you. Let's get back on the record, please. Let's stay forward. Mr. Demons, he's present along with his counsel and the assistant state attorney. Do you want to state your appearances?
Daniel Aronson on behalf of Mr. Demons, Stu Adelstein also present, Raven Liberty, and James Benjamin in back. And Mr. Demons is present.
Good morning.
Good morning,
Your Honor.
Good morning, Your Honor. Stephen Klinger and Nicole Bloom on behalf of the State Bar.
All right, so we all set to proceed. We have a motion to dismiss, I think.
Yeah, that's the last motion I believe we have pending as far as the sets that we had for this week. Your Honor, I think we have an agreement with the state. Instead of calling Ms. Boutros again and calling Ms. Bradley again, with the court's agreement, we agreed that we will stipulate to their testimony that was taken during the motion to recuse and use that as if it was testimony for this hearing to a motion to dismiss, because it would be identical testimony. There wouldn't be anything different.
I have no issue with that, Your Honor.
So it's agreed. That's fine. So regarding the deposition of both Ms. Boutros, excuse me, it's the trial testimony, the hearing testimony, not the deposition.
Right, the hearing testimony.
Of Ms. Boutros and Ms. Bradley. And do you have copies of those? Did you order transcripts?
I do not.
I mean, I heard the testimony. I have notes, but I didn't know if you were ordering a transcript or not.
I'm sure at some time, well, we have not. I did not know until this morning we had this stipulation or anything.
Well, if there is a stipulation and it's done, is it going to be ordered?
We'll order it.
Okay, so then you can
And we'll submit it.
Submit a copy to me.
Yes.
Thank you.
Your Honor, with that said, with that stipulation, we would also now would have been calling State Attorney Pryor, Assistant State Attorney Falk, and Assistant State Attorney Hillary. You have entered your order. We respect your order. We cannot call them. So therefore, we don't have any more witnesses. But I would like to proffer what I believe we would get if, in fact, we were able to call them as witnesses.
Go ahead.
Your Honor, what we believe we would find that if we call them as witnesses is that Ms. Boutros, as she testified to, immediately upon hearing what Detective Moretti solicited to Deputy Gorel, she informed her supervisor, Mr. Killeran. We believe with the testimony would be that Mr. Killeran then went and he talked to the supervisors in the office. My understanding is we will find out that, in fact, there was a meeting with Ms. Bradley with the supervisors in the office, and when I say that, I believe at times it was just the state attorney, and at times it was the state attorney with Ms. Falk also. I don't know which times they were together or separate, but I do know that they were talked to in conjunction with each other and separate. We believe that we would have testimony that they were instructing Ms. Bradley to file the Brady notice, and this goes back as early as basically in October, November, whenever that was, of 2022. The testimony will show that after they did that, pretty much everybody put their head in the sand. They did not check into things. She went through a whole trial. We sat through the trial. Nothing was mentioned about Brady. We find it hard to believe that nobody would have asked her, even after the hung jury, well, how did you handle that Brady issue? What happened with the impeachment of Moretti? Those are things that after a trial are just talked about. But regardless of, we don't know what was talked about, that's what we would try to find out about. We know that even after the hung jury, Brady, as far as what we're talking about, this impeachment material, was not provided. And it continued not to be provided until Ms. Boutros took it upon herself to allow the world to know that the state was hiding evidence. Anyhow, you have the three different Brady, you have four Brady notices, so you have three different ones as far as the impeachment material goes. And if you notice, one is signed by Ms. Bradley, and one by Mr. Killeran. Why we believe the testimony would be that Ms. Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, it was handed to her by her secretary, and she said, I'm not signing this, and that's why Mr. Killeran from Public Corruptions had to sign that Brady notice. So she refused the state attorney's basically edict. Then she turned around and she files another subsequent Brady notice. What happens to Ms. Bradley during this entire time? Absolutely nothing from what we know. What we do know is even when we filed a motion to recuse her because of this, the state vehemently has been opposing that. So they didn't sanction her. They buried their heads in the sand as far as what she was doing. They allowed her to do what she was doing after it comes to their attention, after the mistrial, that she's committed a Brady violation, and they tell her to basically get the Brady notice out. She refuses. When they send out one, she changes it and says that's inaccurate, and they do nothing to her except fight to keep her on this case. That's institutional. Then we're here in front of this court, and I said to Ms. Bradley, can we stipulate to the testimony of Ms. Boutros when it comes to the motions to suppress? Or do I have to bring her back the 13, 17 times? And she says, you got to bring her back for each one. That's retaliation. That's retaliation because she had the courage to tell the truth. And that goes to the office of the state attorneys. You put it all together. There was a mistrial. They hid Brady material. Making Mr. Demons go through another trial is a violation of double jeopardy. Jeopardy should have attached because of what occurred. Now, I filed the motion, and I don't want to go through everything in that motion again. I'd like the court to accept that motion as what I would also and add it to my argument instead of just being redundant. I believe it automatically is, but I would just like to state that. Anyhow, the bottom line of it is, I've cited to the court Glosson versus State and some other cases. I did not cite to the court one case of this fact situation. Again, I don't know if a case of this fact situation even exists, but Glosson tells us that the actions of the state attorney's office can be such a violation of due process that due process demands a dismissal and not a retrial. And that is what we're saying here to this court, that it's the due process violation making Mr. Demons go through court, a whole trial where he's facing the death penalty, while the state is holding on to that Brady material. And then even afterwards it doesn't get revealed until somebody else has the courage to come forward, is institutional. And if the case I've cited of Izquierdo, again, not on point. That case deals with the fact that a state attorney apparently had been sanctioned by his office or disciplined by his office before for comments that he made. And then that trial just goes overboard. The case is reversed. It goes back all the way up to the Supreme Court the second time. And what they basically said is that the case can be dismissed. Izquierdo did not put on enough evidence at the trial level when it was remanded. He relied on the original appellate decision thinking that he was a winner. So the bottom line of it is that if you have institutional, I'm not going to say corruption, malfeasance, and is part of that institution, then this court has the power to dismiss. And under these facts, we ask the court to exercise that power because double jeopardy will be violated if you don't. Okay, sorry. Now, Your Honor, I have here statute 838.022. It is a crime in the state of Florida. It is unlawful for a public servant or public contractor to knowingly and intentionally obtain a benefit for any person or to cause unlawful harm to another by A, falsifying or causing another person to falsify any official record or official document. I contend that Detective Moretti was violating this statute.
So but we're going to object only to the outside four corners of this motion. Now he's making the argument is not adhering to the motion.
Thank you. Understand your objection. We'll proceed.
C of the same statute, obstructing, delaying, or preventing the communication of information relating to the commission of a felony that directly involves or affects the government entity served by the public servant or public contractor. The state attorney's office itself violated C, obstructing, delaying, or preventing the communication of information relating to the commission of a felony, and that's the felony we're talking about is what Moretti did, that directly involves or affects the government entity, the government entity by the public servant or public contractor. So, Your Honor, what we're saying also is not only was there bad behavior, but quite candidly, the state attorney's office, the way they handle this, are party to criminal activity and committed criminal activity. Based upon that, we've also asked this court to dismiss it. But more than anything, when you look at all this case law on it, it's really the totality of the circumstances. It's not, hey, if you do A, that's bad, if you do B, whatever. It's you look at the whole picture. And this whole picture demands that this court exercise its jurisdiction, determine that it was institutional, and dismiss the charges. Thank you.
Thank you. Yes, sir.
Good morning, Judge. First of all, I would like to state that counsel was giving a proffer to the court, and then that proffer sort of merged into the case law and counsel's reasoning. So, but that was just a proffer. They don't have that evidence in this hearing, and therefore this court has everything he was arguing about, the institutional problems in the state attorney's office, and there was no charge filed, that they're hiding evidence. All of that is not on the record for the argument for this motion to dismiss. None of that. They only have what was said in the two testimony from Bradley and from Ms. Boutros. And that testimony indicated that the office of the state attorney told them to tell the truth, told them, let Boutros testify, let them talk to the defense, and there was no indication of any hiding of evidence. There was no indication of institutional obstruction of justice within the state attorney's office. There was no evidence at all that that prosecutors were told by administration to do something illegal or told to hide anything. That was all a proffer he would do, and then he uses the proffer to say, okay, well, the court should, under the law, dismiss the case. There's nothing here that would allow the court to dismiss the case or dismiss the indictment. The normal remedy for a Brady violation is a new trial. Of course, here, that's not an issue because the defendant is getting a new trial, and they are aware of the statements that were made by Detective Moretti, and therefore there's no prejudice going into the new trial. I want the court to know I'm being very respectful of your orders yesterday. I just have to make a record for the state since we're sort of going back to talking about Brady evidence and materiality in this motion. Again, I'm not trying to underlie what the court wrote. I'm just making a record on the part of the state, which kind of is mentioned in the court's order yesterday on granting the recusal of Mr. Ratcliffe. And as the court stated, the state has been arguing that this is a collateral issue. At least the investigations that Ms. Boutros and Detective Moretti were conducting when they seized the cell phone from Ms. King, and he allegedly made the statement asking the Deputy Gorell to say that he was there at the time of the seizure. We still maintain that as a collateral issue. To a degree, I think maybe the court is at a slight disadvantage because the court has only heard maybe people talking about that investigation and doesn't really know the substance of it. And the state would be more than glad to alter.
I'm going to object. I think we're getting into a rehearing on your ruling, not on.
Excuse me. This is counsel's opportunity to respond to the argument. Let them respond to it. But again, both state and defense could call any witnesses they want at the hearing. Detective Moretti wasn't a witness who was called by anybody. So I really don't know what Detective Moretti would say if called to the stand and testify. All right. So you proceed with your argument.
The state would suggest that if the court would like, the court could do a in-camera inspection of the investigation itself. And that would allow the court to look over the investigation, be aware of all the factors when looking at the issue of whether or not that's a collateral investigation or not. So the state is offering to the court to provide that investigation to the court for an in-camera inspection to help the court.
What investigation are you talking about, the Miramar?
The investigation into the weapons tampering that ASA Mr. Boutros and Detective Moretti were in the room that day and taking the statement from Ms. King.
Who was doing this investigation?
The investigation was being handled by the state attorney's office, and by Mr. Boutros was handling the investigation along with Detective Moretti.
Not the Miramar investigation. I was told, and I thought it came up in the hearing, that there was some type of internal affairs investigation that was done by the city of Miramar.
It was.
Later on, yes, sir, a year later.
I just wanted to clarify what investigation you were talking about.
I'm sorry, no, this was just the investigation that Mr. Boutros and was conducting at that time into witness tampering. And that would just be with Detective Moretti. They were there to take a statement. Ms. King, her attorney, was there, Mr. Crackman, and that's when the statement was supposedly made. That would be that investigation.
Thank you. Go ahead.
So, again, and now, Judge, I am going to reiterate the state's arguments.
Gifford, I have to object. He's even stating, he's reiterating the arguments they had on other motions.
Thank you. Just finish up. And I'm not trying to rush you. I didn't mean that to say
it overlapped, so it's hard because in this motion to dismiss, the defense says at the very end, and that's the third prong of Brady. And the third prong of Brady is materiality. And to start, I can't answer the motion without talking about materiality, whether the statement was material. It has to be material to the case, right? So collateral issues don't fall under that. It's material to the case if we're looking to determine whether a Brady violation occurred. So when you start with that, the statement must be, we know, evidence, the statement must be relevant, right? It must apply to a matter of issue and not be immaterial. And the state's argument has been that this is an impermissible state impeachment evidence based on a collateral issue. That is why we want to do camera inspection. That particular investigation is not part of the homicide in any way, shape, or form, the facts of the homicide. So, again, not collateral would be the first argument. The second argument being that when you get to the issue of credibility of the statement, you're bringing in witnesses, right, that are testifying to something that they weren't a party to. Ms. Brennan wasn't there. So her testimony, she would be coming in testifying for a collateral issue wherein she was not even a witness to the initial incident. So it's not Brady in the sense that that material is not reasonably probable to cause a different outcome in the trial. That is the main point of Brady. That is what they look at. They say, well, you have to look at this evidence. That evidence is going to make a difference in the outcome. And in this case, when you go to the first argument is collateral evidence, and then you say you're going to have the witnesses come in and they're going to be giving impeachment. Well, if the detective maintains the statement and they want to call Ms. Boutros to counter that. That is not permissible in the sense that now they're commenting or trying to impeach the witness, the detective, with evidence that of a prior bad act. And you cannot do that. You can only impeach with character. You're going to say character evidence, he's not truthful, you're going to bring in witnesses to show that he's not truthful, that's permissible. But it's not permissible to impeach the detective with a prior bad act. Now, I'm aware that the court, in its order on accusing Ms. Bradley, argues that it was material, that the execution of search warrant material falls within the exception to the collateral impeachment. So the court basically was saying there's an exception, and where there's any doubt that a witness might have bias or motive. But again, I understand that's the exception that the court cites, but in this instance, there's no possible bias in the sense that nothing's pending against the detective, there's no charges pending against him, there's no reason for him to come in to lie. So it becomes a little difficult when you're saying, okay, there's an exception to the collateral impeachment rule, but even those exceptions, bias or motive, to exaggerate, and I'm quoting from your order, or even fabricate his or her testimony, the defendant has a right to explore that bias or motive before the jury. But there's no indication that there was any bias or any motive. There's no charges against him. There's nothing. And you don't know, like you said, you haven't heard from him. You don't even know what his response would be. But he was called and asked whether he said the statement. And that even gets into another issue. If he says, yes, I said it. Well, then what? Of course, it's up to the defense at that point. But if he says, yes, I said it, why in the world if they want to call anybody, they got what they wanted? I mean, you better call, you can't call it Boutros, because she's going to give consistent testimony then. And for them to call Ms. Bradley at that point to what? To question what they wanted. They got, the officer gave them what they wanted. He made that statement about asking the other officer to lie. That doesn't make any sense. If he comes in and he maintains, hey, I didn't take it, I never said it. Well, at that point, they're going to bring Ms. Boutros in to say the opposite. But to bring Ms. Bradley in, just say it would be a consistent statement. But she is going to say, be consistent with his testimony. So we have those issues, but then I agree that, because there is an exception that the court cites in its order yesterday, but I don't see how they're going to be able to discredit the witness through bias or lack of competency when there's nothing pending against the officer. There's no reason for him to come in and lie. I would say to the court, there's a lot of arguments were made in the state's memorandum of law that was filed Monday in support of an order denying the defendant's motion to use the state attorney's office. Those arguments apply here because it would be the same thing. And that's why I apologize to you. I don't mean to be going against your order, but I'm just having to renew those arguments because they apply to both cases in the sense that you're looking at whether or not we're Brady yet. And so I would ask to adopt the legal reasoning that's found in the state's memorandum of law in support of an order denying the defendant's motion to refuse into these motions, the arguments with the state on the motion to dismiss. And again, we offer to the court to take a look at give an in-camera inspection, not a proper in-camera inspection of the investigation itself, to see whether or not the court can make a further determination as to whether that's collateral to the issue. Because that's the first step in Brady. It's got to be material to this case. And when you have another case, it doesn't apply. The defense has gone a step further, giving a proffer and trying to say that there's corruption in the state attorney's office. hiding things. And again, none of that was shown to the court. Now, that's not part of the record. So the court made a reasonable ruling on the motion to quash. They're not testifying. Therefore, they have the testimony of Mr. Cruz, they have the testimony of Ms. Bradley, and that certainly doesn't rise to the level of a due process violation. There's been no showing whatsoever of an institutional issue with the state attorney's office itself. The court made such a for the most part, never said there was even prosecutorial misconduct. So to get to a due process violation that would require dismissal of the indictment, they don't have the evidence for that. And therefore the court must dismiss or deny the motion to dismiss the indictment.
Thanks.
Your Honor, to the extent that you were going to revisit the Brady issue, I was not prepared to argue that today. I didn't think that's what was on for today. And if you are going to be reconsidering that issue, I certainly like the opportunity to address it with case law that I have and the files that I have and whatnot. We think your order as to that issue is exactly on target, and we do not have a problem with it. I do want to point out just one thing that was said, and that is that Detective Moretti getting on the witness stand, and if he acknowledges that he said those things, we can't impeach. So the state is saying that Detective Moretti would get on the witness stand and confess to a third-degree felony and probably some misdemeanors. And that's part of their argument. You know what? If it turns out that way, that he's willing to confess to a crime on the witness stand, we'll live with it. Other than that, I stand by my other arguments.
Thank you. So, counsel, I'll defer ruling, take it under advisement. State asked and offered an in-camera inspection of Ms. Boutros' state attorney investigation. Any objection to that?
Your Honor, yes, because we know that a lot of the stuff was verbal comments that were made, and I don't know how the court gets those verbal comments that were made to each other and whatnot. So I think you're only getting half the picture if you do that.
I'm going to think about that. As far as the transcripts of both Ms. Bradley, the testimony, not trial testimony they give, you need a minute? She's already no. Take your time. You need a minute?
Judge Butterfly, can I address the transcript issue?
Just 1 second, all right? All ready?
Your Honor, I think it's important to just note the sequence of events as far as Detective Moretti. Detective Moretti's statement occurred after the seizing of the phone from Ms. King, after the search warrant and whatnot. It's all part and parcel to this case, as the court has found. Bottom line of it, Your Honor, is we just stand by our mission.
Thank you. Ms. Liberty wanted to chime in. I was asking you about the transcript because you're saying that you're relying on the evidence from the trial hearing testimony from both Ms. Boutros and Ms. Bradley, and I was just inquiring as to when you anticipated having that. Ms. Liberty was chiming in to offer me a suggestion that day.
So we tried to order the trial transcript. We were quoted $5,000 for the cost of that hearing transcript. I said $5,000 is a little expensive because we're still having them work overtime getting us the transcripts from the last trial at this point. So we don't have the transcripts. I think even if I was to order it on a regular order, not rush, I'm looking at a month.
Thank you. I don't know about that. I don't know how long it takes, to be candid with you. I don't keep track of that, but it's, I don't know that you need this overnight or anything. I mean,
no.
We have 30-plus motions to resolve.
And I think you just need it for the record right now.
Right, I took my own notes and things like that.
Yeah, so we'll just order it normal, and then we'll supplement the file.
Is that all right?
That's fine, so,
All right. So let me switch topics. Who's going to handle this?
We just received your order yesterday, so they're working on it nonstop. So we'll have somebody.
And again, I don't know what the state's anticipating. I mean, and no, I don't take it as any disrespect or anything like that. Are you anticipating filing something with the higher court to challenge the ruling or not? Or is that something still in discussion or debate? I'm trying to get an idea of where we're going and what the schedule's going to be like.
There is still some discussion, but as of right now, no, we have not.
So you're still in the process of trying to find out who the attorney is going to handle the case.
That's correct. And we're close to a decision, but we don't have it. There's stuff that we need for the moment. That issue.
Always welcome, counsel. The issue I have going forward is we started talking about hearings starting on Monday with some of these motions. There's in excess of 30, fair enough? I mean, in excess of 30 motions that are outstanding. I know there's 13 motions to suppress, and I need to get them scheduled because we're on a time crunch. So when and where, and I believe I wasn't present when it happened, but my understanding was Ms. Liberty was trying to find out and get some time for hearings. At least my office was contacted the other day, and they were asking about when we scheduling hearings. I told them we'll talk about it today. I told my secretary to tell Ms. Liberty to talk about it today. I'm trying to get an idea of when we can schedule these hearings so everybody knows, so we can get on it. Because there's a lot. And I know when Ms. Bradley was here, she was talking about on some of them there was issues that were, I don't want to say commingled, but their same testimony might be to resolve those issues, and we could take 3 or 4 of them on the same day, something to that effect. I don't know if those discussions, who's having those discussions, and what scheduling has been agreed to at this point.
I'll answer that for you, Your Honor. Ms. Bradley and I have a failure to communicate. As one of my favorite movies always use that phrase. Bottom line of it is that we did not work out any scheduling orders. In fact, we have a disagreement as to what motions can be heard.
And Judge, also,
Excuse me, I'm sorry.
I'm sorry.
I don't understand as to when you say what motions can be heard.
Well, I believe Ms. Bradley would contend that some of the motions are moot because they've been heard before or whatever, and I think she would contend that some of them are not going to be heard because they're not going to be introducing that evidence and whatnot. So I don't know which ones the state thinks are right and which ones aren't. Right now, all the ones we filed, we believe are right until we find out otherwise.
And Judge, I spoke to Ms. Bloom before this hearing started.
Ms. who?
Bloom.
Blue. I'm sorry.
Yeah, sorry.
I thought you said blue.
I mumble sometimes, I apologize. So anyway, the state's position is we got to figure out who's going to be handling the case. And as soon as that happens, we'll get with the new prosecutor and try to work out all the logistics. And of course, the side issue is the state listed, 20 new witnesses. 22, I was close, that we have never heard of before that we need to take depots. So we're going to have to try to schedule in between jury selection and everything else in motion practice that part. So we'll discuss.
Excuse me one second. Do you know who these witnesses are?
No, I know there was new witnesses listed, but I cannot tell you the relevant relation to the case.
This has to do with the new allegations?
I believe this has to do, well, it may, but I also believe it has to do with the main case.
May I respond, Judge?
Sure. I'm just trying to get an idea.
Sure.
I was preparing a motion regarding these depositions because I've been trying to schedule depositions for about 3 weeks. As of yesterday, I finally just laid out number 1, number 2, number 3 to Ms. Bradley who needs to be deposed. They are not all regarding the new case. Actually, we've seen motions saying nothing about the witness tampering was going to be brought up in the murder case for Mrs. Klinger. 2 motions. So we got, I believe, 10 inmates that are testifying about gang activity, which would be after the date of the murder. I don't really think it's relevant, but we have new experts on the case. I did, in an email, ask where are the reports for the experts. I was told she was at the doctor's office and she would get back to me. Instead, I got your order recusing her. I did try to speak to counsel today. I offered up my Saturdays and Sundays to get these witnesses done. I have 3 of my own motions going specifically to evidence provided in the cell mapping and the pedometer. I have been given a new witness for the pedometer. I'm assuming after I wrote the motion to keep Detective Moretti from testifying, the state added somebody else now to testify about the pedometer. I need to depose them immediately.
Thank you. So, when is this decision going to be made as to who the attorney is?
It will be made very, very soon. I'm sure it will be made by either the end of the day or by Monday.
Well, Monday, we were supposed to start hearings. So, assuming we started the hearings on Monday, who's going to be? Is that you?
Right. Well, yeah, it may well be, but I can't really answer as to who it would be other than. And I also want to, when counsel said that in my motion, anything in my motion referred to the investigation and asked you to look at it.
No, your motions were really clear that none of the evidence from the witness tampering case would be used in the murder case. You wrote it twice in 2 different motions.
Your Honor, if I may, let's continue on behalf of the state. The state's motions and memorandums are very clear. This is regarding the witness tampering investigation that Ms. Boutros was conducting. This has nothing to do with the subsequent arrests that were made. And as Mr. Klinger indicated, this in-camera hearing or in-camera review is for specifically that investigation, which still remains open. And it has nothing to do with the conversations that the counsel had indicated it's all verbal. This has nothing to do with the conversations that occurred after the fact, after the statement by Mr. Moretti. This is the actual investigation, the purpose for the subpoena, the purpose for the statement. It's an open investigation. It has nothing to do with the pending charges and the new arrests.
So this is the way, I told you I would defer ruling on that issue as well as the motion to dismiss. I'll let you know if we'll conduct an in-camera inspection of what's going on in this investigation by Ms. Boutros. My concern, I guess, is we're supposed to be in trial now, and I know my order upset the apple cart a little bit because we don't know who this assistant state attorney handling it is. The case, but the concern, I guess, is that this is a speed trial where it's an issue. My understanding is that once the speeding time expires, I think it already has it. No?
We got reached the verdict on the 21st. The 21st falls on a Saturday, so on the timing rules, it would be the next Monday, which would be the 23rd.
So you have you've looked at this, so you think it expires when?
The 23rd of this month, October 23rd.
All right, so October 23rd of this month. So, and I know there's, certain other caveats that have to happen. Council they have 30 motions that they filed recently as a new defense team, new additions to the defense team. And there's a lot of motions that need to get heard. I understand all of that, but we all are under the gun, so to speak, because there's speedy trial. My understanding from the defense, they've made perfectly clear they're not asking for continuance. They want to have the motions heard and they want to be able to go to trial. That's the way I understand it. So it's really imperative that I know who's handling the case for the state.
I understand, Your Honor. And again, I think, you brought up the defense continuance. They wanted to vote witnesses. They are filing motions. They should be taking a defense continuance in order to be preparing for their case. However, I also have another solution for the court, if the court doesn't mind me giving one. And that would be Judge Fine picked a jury this week on a capital case. He had 250 jurors coming in next Wednesday. They were reserved for it, but they got the jury this week. Those jurors are in fact available. So that the court could go ahead, because of the prejudice in the state, in the sense that we now have a new prosecutor on the case. And this prosecutor has to get ready. And in order not to prejudice the victims' families and the state and the people of the state of Florida, you could bring a panel in on Wednesday, swear them, and have them come back later on or after the holiday. And then not be a speedy trial. All of these motions could be set and depositions could all be said within a reasonable time period between then and when the jurors are coming back without any other issues with speed, and they could be heard with everybody having a chance to be prepared.
Understood, and I don't disagree with anything you said, but that doesn't mean that's the way it's going to happen. It's a distinct possibility, but it's also, assuming that if this defense intends on filing a notice of expiration on, you said the 23rd is the date, is that right?
Yes, unless you want me to go to the 21st.
Stating we're not until the 23rd. We would have to file a notice on the 24th.
So if they intend to file their notice on the 24th, I intend to start the trial. And, no disrespect to defense counsel, these motions and depositions are going to be put to the side, so to speak. We're going to go forward on trial. That's what you want, that's what we'll do. If you want to get the motions and the depositions taken care of beforehand, I mean, we're going to go on trial Monday through Thursday. I think that's what Ms. Bradley and you all indicated that you wanted to do on it. You wanted to say Fridays for whatever type of work you were doing. And I said okay to that unless there's some change. I'll find out who the new prosecutor is on it. We can talk about it, but my thought is we're going to be going Monday through Thursday, and you can do what you need to do on Fridays.
I think our calculation maybe it's need to run this earlier than the dates of their session.
I think it may be on that Friday.
It might be on the 20th,
Yeah, because you're.
I'll take it, I'll take the 20th. I'll take the 20th, Judge.
I think you're right.
so there may be less time
Great.
in that sense.
Whatever it is, and you'll know and you'll let me know, but the point is, we're up in a time crunch.
And let me ask also the court, I appreciate the court at least considering the proposal that I made. And also, I know the court's ruling, and it seems as though that a ruling on Ms. Bradley Price applies to trial, because that's how the defendant's process was to be violated during trial. Is the court ruling that she could not handle the motions, still not handle the motions themselves?
She should be out of the case now.
Judge, the only other thing I wanted to add, Your Honor, is the state proffered and Your Honor agreed to see these materials in camera. If
I didn't agree with that.
Oh, take it under advisement. So if in fact you do decide to do that, let us know. And we just ask if you find that it's something that we can have and it is discoverable, we'd like a copy as soon as that decision will be made. That's all.
Well, they're telling me it's something about an ongoing investigation. It's still pending. So typically, that is not something that would be shared with the defendant. I don't know what it pertains to specifically. I have no knowledge of it, but I mean, if it's something that I don't know.
Sure, and that's why I'm asking is that this began before October of 2022. So if it's still ongoing, if Your Honor notices that there's no activity since October of 22, that maybe there would be more to it than just them categorizing it an ongoing investigation. So that's all I'm suggesting, is that it may be discoverable regardless of how they label it.
Thank you. Anything else?
There is still a help the court if the court wanted.
I'll let you know. Again, I don't know if something I want to look at, because if it's an ongoing pending investigation, it's not something I can really share with the defense. And I don't like, I never really like doing that, to be candidly. So it's not something you can share in open court. I don't know what my feeling is, so let me think about that.
All right.
But I need to know about the attorney, because I need to know when I can schedule hearings. And there's 13 motions to suppress, and I want to get those resolved. I don't know if the witnesses, I assume they're under subpoena for the trial period now, because we were supposed to be starting this week.
Your Honor, the last time you made that comment, Ms. Bradley was here, and she said because the jury selection was going to take so long, that the witnesses were not under subpoena.
So if that's the case, I don't know if it's the case or not. I don't remember what Ms. Bradley said, but if that's the case and there's no witnesses under subpoena, how long would it take the state to get witnesses for this, for these motions?
As soon as we know, and it won't be long, who is going to be handling the case, we will advise the defense of the court. And that is why, again, the suggestion of taking the jury to Judge Fine would certainly help in the situation, certainly prejudice in the state in the sense that for a new prosecutor to take over this, it's a double homicide, we're asking for the death penalty, it's a case. That's a lot for a prosecutor to, last minute to be trying to learn and to understand and be able to make argument on. And that's why we made the suggestion to the court of holding in the panel next week on Wednesday, swearing them in, asking them to come back, and then letting the prosecution have the time to prepare for such a large case and these complicated motions. And it will also give the defense time to do their depositions and file whatever motions they want, new motions they can file.
Thank you. Anything else to discuss at this point?
I do have, so since we're doing scheduling, I did have one motion that's not a motion to eliminate. It was basically, it started off as a motion to compel, which would be my second one, to get the cell map evidence. We did get a new expert, which I listed. My new expert went through the documents and then informed me that all the CDRs that the state has been provided are not what comes from a cellular company. They went even further and pointed out that somebody went into the evidence that's supposed to be direct from the mobile company and put phone numbers, the names, assigned names to phone numbers. So I would ask that that hearing be held as soon as possible because we do have an evidence, huge evidence issue that needs to be resolved immediately.
Thank you. Well, I'm not going to get involved in that until I know who the prosecutor is. I need to know who the prosecutor is. So my thought is I'll set a hearing. If you have decisions going to be made, you think today or Monday?
Yes.
All right. So if I put this on the docket for Tuesday, does that work? You'll know who it is, and somebody's going to have an opportunity to discuss. I guess whoever's going to do it is going to discuss with the defense counsel about scheduling these motions and which ones are going to go first and which ones you want to do and which ones you need testimony on and where the witnesses are, whether they're available and how long they're going to be, because there needs to be some discussion regarding that with the defense counsel.
I have the bulk of the motions I've written that I will be happy to coordinate in any way I can with the new state attorney.
All right, so are we done? Yes?
And Judge, while we're on the record, I do have 4 USBs that were provided by Ms. Bradley to provide defense, so I just want to do that on the record.
Thank you.
Thank you, Your Honor.
Can I see counsel sidebar, please?